flirty with it.
Where did you do that?
Minnesota called that out.
Oh, yeah, that's cool.
Yeah, I loved it.
Mary Carr was there. A writer.
Oh.
I think,
Well, Kofi Annan went there, and what's his name, the Democratic presidential candidate, Walter Mondale. It was great. They have a big emphasis on internationalism, and they require like 95% of the majors to study abroad.
Cool.
Which is really cool.
So while we were just sitting here, we got into another topic.
Oh, really?
What was that?
Oh,
okay. That's good.
I know.
I'm
feeling a little stressed already.
Should I do an introduction?
Sure.
Okay. Pardon?
We're just unmuting the mics right now, so then you'll be ready to go.
Just going to be doing the...
Do you have a handheld mic?
I do.
Or do you want the handheld? Maybe I'll hold the handheld, because I'm just going to talk for a second, and then...
Yeah, I can do the handheld too, that way you don't have to worry about the handheld one.
Okay, who's going to be at the...
Oh. Is it like filming now?
Yep.
But
Okay.
Hello. Welcome to the World Peace Through Law section webcast for March 29, 2013. This program is not a continuing legal education program. It's educational in the sense that we're going to help you earn CLE credits while providing a valuable service to contributing to law and peace. Immigrants and asylum seekers are among the most disadvantaged people in our legal system, and providing them with the assistance to which they are entitled is a way in which you can make an actual physical contribution to law through peace. Leading our program today is Jordan Wasserman of the Northwest Immigrant Rights Project. Jordan.
Hello. Thank you for attending. We've never participated in webcasts, so we don't know how many people are actually attending, but for those of you that are out there, thank you. I am the pro bono coordinating attorney at the Northwest Immigrant Rights Project. Part of the reason we're presenting today is to educate the community about the needs that are out there, and also to encourage attorneys to get in touch with our organization to take pro bono cases. And for those people who do sign on to take pro bono cases, you will get ample assistance throughout. You'll get plenty of support. So you don't need to be an experienced immigration attorney. And in fact, two of our presenters today, one is going to be Betsy Tao, who is the lead attorney in our Tacoma office, which their staff deals exclusively with the detained population at the Northwest Detention Center. And then the second presenter is going to be Betsy Rosenman, who, like you, was probably not experienced in immigration law, but she has turned into one of our superstar pro bono attorneys, and she's going to tell you about her experiences and hopefully encourage you to recognize that you too can get involved and take cases. So the Northwest Immigrant Rights Project, just a little background, is that we're a medium-sized nonprofit organization. We promote justice for low-income immigrants by pursuing and defending their legal status. We provide direct representation, which is supported by education and public policy work. We have 4 offices throughout the state of Washington. Seattle, which is where I work, is our largest. Tacoma, which, like I said, works with the detained population there. And then we have 2 offices, one in Granger and one in Moses Lake. We, I think, organization-wide have about 18 attorneys and 35 to 40 full-time staff in total. Each year, we refer out a lot of pro bono cases, and typically we're referring out over 225 cases a year, which I think is awesome, and we hope to continue to do that in the future. NIRP has a tremendous need for pro bono representation. To give you an idea of that need, we receive approximately 1,500 calls for assistance every week. And over the course of the year, we help over 10,000 individuals and families apply for visas, avoid deportation, so, you know, while our staff is relatively small, we are able to help a lot of people. In addition, and Betsy Tao is going to talk a little bit about this, but there's a tremendous need for representation at the detention center, and she'll probably have better statistics, but there are about a little less than 1,500 beds there, and I think between 80 and 90% of the individuals that are detained there end up going pro se. Unlike in the criminal context, you do not have a constitutional right to a government-paid attorney if you can't afford one. So, you know, because of that, there's just a tremendous need for representation. I also wanted to mention that in addition to doing great work by volunteering through our organization, you can get up to 6 CLE credits a year by doing volunteer work through an organization like the Northwest Immigrant Rights Project. So hopefully that's an additional incentive. I think I'm going to turn it over to Betsy Tao because she's going to discuss working at the detention center. Just so you know, we offer a lot of different types of pro bono opportunities. We, you know, if you are concerned about appearing in court or you really want to appear in court, we can find an opportunity that will satisfy that. And if you want to represent someone at the detention center, that's an option. If you do not want to represent someone at the detention center, there's also a local immigration court in Seattle that you could appear in. If you don't want to appear in court at all, we also have opportunities for those individuals. You know, so the most important thing is that if you are interested in getting involved, please just contact me. My phone number is 206-957-8632. Again, that's 206-957-8632. And my email address is just Jordan, Jordan, @nwirp.org. Thank you very much.
Hi, everybody. So I'm Betsy from the Northwest Immigrant Rights Project, and I'm going to be talking about representing immigrant detainees. And what I'd like to do, because I'm assuming that most people who are participating don't know very much about immigration detention, and definitely little to none about representing immigrants in a detained setting, I just kind of like to keep it pretty basic and demystify things a little bit. So the agenda for my very brief discussion or presentation, I'm going to talk a little bit more about the work that we do in our Tacoma office. And then I will talk a little bit about immigration detention, what it is, what the history of it is, and then focusing locally on the Northwest Detention Center, which is the privately contracted 1,500-bed facility where we do our work in Tacoma, Washington. Following that, I will talk about why detention work is such a priority for NERP, and why if you were to get involved and took a detained case, you will be furthering peace through law. I'll talk a little bit about the government players that you would be dealing with if you did take a detained removal case, and then I'll just end with a very quick overview of how removal proceedings work kind of from beginning to end. So as Jordan said, Northwest Immigrant Rights Project is a nonprofit law firm that provides comprehensive legal services to low-income immigrants and refugees. We have 4 offices. I work in the Tacoma office, and the Tacoma office is focused on doing detention work and removal defense, or deportation defense. So one of the main services that we provide is we provide a lot of hand-holding to all the pro se detainees. So the vast majority of people at the Northwest Detention Center, and actually the vast majority of people in detention, are unrepresented by an attorney. So the last time I actually saw government statistics for our local detention center, it was over 90% going through deportation proceedings were unrepresented. This was in 2008. Anecdotally, it doesn't seem like that has changed much. And I'm sure it's about like that around the country. So that's why what we focus on is trying to provide legal services, and training and empowerment to those people who are, without any other option going to appear before the immigration court on their own. And then in addition to that, we try to refer as many cases to pro bono attorneys as possible. And our office also takes on cases directly. It's just that because we only have 4 attorneys of the over 5,000 people that we see each year, our office is only able to represent maybe 50 of those individuals. So one of the reasons why detention work is such a priority is just that disparity in numbers between the over 5,000 that we help pro se and the 50 that we can take, not to mention the numbers of people that we may never actually even reach to help pro se. So talking a little bit about immigration detention generally, I thought I'd start with this kind of often used statement about how the federal government is not enforcing our immigration law. So you hear this a lot in the news or in the comment section of an article, if you're unwise enough to read the comment section of news articles. So I found these bar graphs very interesting. This graph, and I don't know if everyone can see it very well on your computer screens, but it is a bar graph showing the U.S. Border Patrol budget from 1992 until 2009. And just looking at the trends, you can see that the numbers sort of exponentially increased, so that back in 1992, it's way down there. And then going over to 2010, it's way up there. So that trend actually continues with the number of Border Patrol agents that are stationed on the southwest border. So back in 1992, you had not even 4,000 Border Patrol agents, but in 2010, that number was almost 17,000. And I haven't seen the numbers for the past 2 to 3 years, but I imagine that they are pretty much up there. The budget for Customs and Border Patrol and Immigration and Customs Enforcement has also gone up pretty dramatically, especially for Customs and Border Patrol. So you can kind of see the trend there. And then moving away from Border Patrol, this is the number of deportation cases in Seattle and Tacoma immigration courts from 2002 to 2008. So that total number is the green line there on the top. And so you can see the total number of cases has gone up pretty steeply. And I thought it's also interesting to see how the detained cases and the non-detained cases compare. So the bottom line there that's blue is the trend for non-detained cases. Now that's actually dropped, peaking sort of in 2006 and then going down a bit, whereas the detained cases have kind of skyrocketed along with the trend of all cases. So that kind of demonstrates that there is now more and more there is a sort of preference to detain people and do the proceedings of detention. So this is kind of a final bar graph just kind of showing that in spite of all of our efforts to use detention as a deterrent, that actually the number of unauthorized immigrants in the United States has grown. Which kind of leads to the question of how effective detention actually is. So historically, immigrants were not detained until the 1890s when the U.S. opened its first federal immigration detention center in Ellis Island. And then there was a shift in immigration policy in 1952 when Congress first passed the Immigration and Nationality Act. And the Immigration and Nationality Act is sort of the piece of immigration law that most of us doing immigration work kind of go to. That's our primary source. So when Congress passed the Immigration and Nationality Act in 1952, that act actually eliminated detention except in cases where an individual is a flight risk or posed a serious risk to society, and as a result, Ellis Island subsequently closed. And then in the 80s, there was a new shift in detention policy influenced by the number of Cuban, Haitian, and Central American refugees that were coming into the U.S. And it wasn't until the 1990s when the U.S. really made a huge shift in immigration policy, using detention as the primary means of enforcement, regardless of whether somebody was a flight risk or a serious risk to society. And then finally, in 1996, the U.S. enacted legislation that dramatically expanded the use of detention, with two laws, one called the Anti-Terrorism and Effective Death Penalty Act, or EDPA, and the Illegal Immigrant Reform and Immigrant Responsibility Act, also called ARIRA, which most immigration practitioners recognize as being pretty harsh law, especially in the way that it expanded mandatory detention, the categories of people who will now be detained without even the possibility of a bond hearing. So here's a chart of kind of showing the cost of detention, the sort of growth in detention population as well as the cost. So the number of detained individuals, because of all these shifts in immigration policy, has obviously grown dramatically since the 1990s. And so, for example, in 2001, the U.S. detained about 95,000 individuals a year, but by 2010, the number of individuals detained has grown to approximately 390,000. And I believe ICE's stated goal is to deport 400,000 non-citizens each year, which it almost met, I believe, in 2011, setting a new record for the agency. The daily population of detained immigrants has grown from about 5,000 in 1994 to 19,000 in 2001 to over 33,000 a day by the end of 2010. And then just thinking about the cost of detaining people, the average cost that ICE has put out there of detaining an immigrant is about $122 per person per day, which is pretty high considering that later I'll talk a little bit about the conditions in detention. You'll see that just looking at space, food, and cost of detaining someone, it's quite a high amount per day that the government is paying to detain people for what they're getting, for what the detainee is getting. So one last point I wanted to make about the 1996 expansion in the categories of people who are under mandatory detention. I believe Betsy is going to talk a little bit later about asylum seekers. There's a group, most people seeking asylum who are picked up by the government at a border are, under the law, subject to mandatory detention. And so this is a group that would be a good example of people who are not a flight risk or a risk to society, but under the current Immigration and Nationality Act as amended by that 1996 law, would now be subject to detention without a possibility of a bond hearing. So I just included this slide because I thought it was inspirational and kind of ironic. So now I'm going to focus on sort of the local detention center, the Northwest Detention Center in Tacoma, Washington. If you did take a detained removal case, this is where you'd be going to meet your client, to talk to ICE and to attend court. So this particular detention facility is the 4th largest in the country for immigration detention, and it's operated by a private group called the GEO Group. GEO Group runs immigration detention centers and prisons around the country. I believe they're actually international. The detention center was built in 2004, and there's a capacity of 1,575 beds. Approximately 90% of the detainees are men and about 10% are women, and over 70 countries thereabouts is represented at the detention center, with 66% being Mexican, and probably 75% being both Mexican or Central American. There's different security classifications. So the detention center is meant to be, not a criminal detention facility. It's meant to be a civil detention facility, but it's being run by a private contractor that runs prisons, and it pretty much feels like a prison and is run like a prison. So the male detainees are categorized in blue, orange, or red, which are security classifications, and there's rules about who can mix with who. So one thing is that if you do take a case and your client is a red, which would be a high security classification, there are additional obstacles to seeing that client. So this is a picture that is a very accurate representation of one of the living units inside the detention center. So as you can see, in the far wall there's some telephones, and so those are the phones that people use to call their attorney or their families. There's kind of an open area where there are a lot of bunk beds, and then there's, on the periphery, there are sort of two-bed individual cells, and there's 2 levels of those. So people typically prefer to have one of the private cells rather than having one of these open bunks. And then there's sort of like a general recreation area in the middle. Detainees can work at the facility, and a lot of them choose to just because it's so boring otherwise, and they're paid $1 a day to work at the facility. And the kind of work that they do range from cleaning the living unit, working in a barber shop, doing laundry, working in the kitchen, that kind of stuff. There's a medical clinic on site. There's the medical care is pretty much limited to what is necessary to facilitate deportation. And then there's some sort of recreational activities. There's television, there's games. There's no library, but I think there's like one small cart of books that people have donated. The idea is that unlike a prison where there may be classes like, AA classes, a big library, possibility to get a GED, immigration detention lacks all of that, because the purpose of immigration detention is to hold someone temporarily until they can be deported or their case is over. And so from the government's point of view, there's no point in providing classes and too much recreation because it's not meant for long-term incarceration. But sadly, the reality is that most people who are choosing to fight their case or go to court are spending 6 months to a year at least in detention, but they're lacking a lot of the recreation that a prison would. So a little bit about who's at the detention center, what kind of people are actually detained, as in, are they all the criminals? So one, I talked about the asylum seekers. So asylum seekers, under the law, if you are coming to the port of entry at the southern border, or if you're showing up at Blaine, or if you're at SeaTac Airport and you say to the immigration official there, I'm afraid to go back to my country, then you will be put into detention. It's mandatory detention. Asylees and refugees, so these are people who have already gotten asylum or they came in as refugees, but they may have committed a crime that now makes them deportable. Visa overstays, so people who came in on a visitor's visa or a student visa and they overstayed that visa, and then for some reason they came to the attention of immigration and then they got picked up. Undocumented immigrants, I would say a significant portion of the people that we see are people who entered without inspection. Lawful permanent residents are people who have green cards, and so if you are a lawful permanent resident, there is a very, very large category of crimes, including petty thefts that could land you at the detention center and in deportation proceedings, and the occasional U.S. citizen. And so we've seen maybe 30 or so in the past 3 or 4 years, people who actually were citizens, but they just had mental health issues or for whatever reason didn't know that. And then finally, the people in detention include a significant population of people actually have mental illnesses, and we do see pregnant women and other vulnerable populations. People who are LGBTQ are in a particularly difficult position at the detention center because of the way the living units are organized. And so what we found is that if somebody can't be in the male living unit or the female living unit, for their own protection, they're actually placed in segregation. So why is detained work such a priority, or immigration detained work? So I thought this was kind of a really interesting chart to look at the criminal justice system versus the immigration justice system. And as you can see, pretty much all of the rights that you would get in the criminal justice system are denied to immigrants, with potentially the most poignant one being that you don't have a right to an attorney that is paid for by the government if you can't afford one. And so, like I talked about from the statistics, over 90% of people who were in detention going through removal proceedings are actually not represented. And nationwide, the number of people not represented who are detained is about 86%. And then just looking at the people who were granted asylum in 2010 without legal representation or with, only 11% of asylum applicants who did not have a lawyer were granted asylum in court. If they had a lawyer, then the odds rose to 54%. So 11% if you don't have a lawyer, 54% chance if you do, with over 90% of people not having an attorney. So it's a pretty good barometer of whether or not you're going to be successful in your claims if you have an attorney versus not having one. When people go to court for the first time, they're handed a free legal services sheet that looks just like this, depending on what immigration court you're in. This is the one that they hand people in Seattle and Tacoma. And so I just included this because, as you can see, for most jurisdictions like Seattle and Tacoma, there is only one organization on that sheet. In Seattle and Tacoma, it's Northwest Immigrant Rights Project. I'll say, and people get that, and there's no other free legal services available. And even though we're the only legal services organization on this sheet locally, Washington is pretty lucky because in many other states, there is no one they can really put on the sheet. There are just no other nonprofits that provide free legal services. Other challenges of just being in detention, as you can imagine, separation from family and other support. When you're detained, so access to counsel becomes a big issue just because the person who's detained is usually the breadwinner, is now not making money, and is going to be much less likely to be able to cough up the money to hire an attorney, because all of the things that they were paying for outside, rent, mortgage, whatever, the family's going to already be struggling because they've lost their primary breadwinner. Language barriers is another big thing that we see. If someone doesn't speak English or Spanish, then oftentimes they may be in the living unit without anybody to talk to or ask questions. Lack of services I already talked about because it's immigration detention and not a prison. Lack of recreation and jobs. And then just mental health issues. I mean, people come in, even people who come in who may be relatively stable, just by virtue of being in immigration detention, oftentimes they kind of deteriorate. If you were to take a detained removal case, the government players are the DHS and DOJ. So DHS, Department of Homeland Security, is sort of the enforcement arm. You have the Immigration and Customs Enforcement, under which there's ERO, or Enforcement and Removal, the Enforcement and Removal Operations. Those are the deportation officers, or in the criminal justice system, I would liken them to sort of like the police. And then ICE counsel are the prosecuting attorneys that are in immigration court. So that would be the person, on the other side of the aisle from you. And then USCIS is also within the Department of Homeland Security, but they have a separate office in Tacoma, Washington, and they're processing mostly affirmative applications rather than dealing with a removal setting. And then the Department of Justice is where the immigration court system is under. So under the DOJ, you have immigration courts and the Board of Immigration Appeals, which is the administrative appeals level of the immigration court system. And so really quickly now, I'm just going to talk a little bit about removal proceedings and what they are. So removal or deportation proceedings is the process to figure out if a person should be deported from the United States. So as an attorney, you would be asking, is my client deportable? So should they even be in removal proceedings? And if they are deportable, do they have some kind of defense? So this is like a very accurate representation of what the immigration court looks like in Tacoma. And this is kind of an overview of the immigration court process from beginning to end. So in many ways, it kind of looks a lot like the criminal justice system. It starts on the far left, top left there in that blue box, you get detained, and this is very similar, process for people who are not detained, but I'm gonna talk about the detained population. You're detained and Immigration and Customs Enforcement, or ICE, issues a notice to appear, which is your charging document. Similar to a charging document in criminal court, it states some facts and has the allegations for why under the law you violated, what section of the law you violated. So about 2 to 3 weeks after they issue the notice to appear, you get what's called a master calendar hearing. And the master calendar hearing is very similar to an arraignment in criminal court. It's pretty quick. There are a lot of other people going through it at the same time. And most people who go through immigration court, they're deported at that master calendar because they are deportable and they're not going to put forth any applications for relief. You get multiple master calendar hearings if you need to. People often get multiple master calendars because they need time to find an attorney or they need time to fill out an application for relief. And eventually, when you submit the application, you get an individual hearing, which is like a bench trial. And here, I have 1 to 2 months between the last master of the individual. Currently, it's actually much farther out than that. So in Tacoma Court, the individual hearings are being scheduled right now in September. If you were to win your case and ICE doesn't appeal, then typically the client gets released. If you were to lose your case, you have various levels of appeal, which take months up to years. So that's why I say there are people anybody who's appealing their case in detention, they're looking at years in detention. And so just a few more slides here. This is what the notice to appear or that charging document looks like. And how do people kind of end up in the removal system? So commonly, it's some kind of interaction with the criminal justice system. That doesn't necessarily mean that somebody's committed a crime, but even if they're just pulled over for having like a broken taillight, that's an interaction with the criminal justice system. And with the sort of increased cooperation between police and ICE, we're seeing this more and more where people are getting picked up because they've encountered police. Sometimes people end up in removal proceedings because they file an application, say an asylum application with USCIS that then gets denied, and then that case gets referred to ICE for prosecution. And then other interactions with ICE and Border Patrol, like the asylum seekers who are stopped at the border. So why do we continue to detain people? These are just sort of like general policy arguments that you guys can think about. As a response to mass migrations, to make sure people appear for court proceedings, to deter immigrants from coming to the United States, a quick fix to the broken immigration policies, and because it's a multi-billion-dollar industry. So there's a lot of reasons why detention has grown so much. Some of the reasons are less sort of justifiable than others. And hopefully that demystified detention work enough that you guys will be really interested in taking a pro bono case, and if not, I'm sure Elizabeth will persuade you. Can you show me how to advance the slide? Sure, it's just the right arrow. Right. Okay, great.
Hi, I'm Betsy Rosenman, and I'm going to speak about the pro bono perspective. I feel like maybe the most important thing I can tell you is at the very beginning, my name and phone number and email address, only because if you're at all interested in taking this kind of a case, please, please, please don't hesitate to contact me. I find the cases to be really rewarding, but if you've never taken one before, it might seem a little overwhelming just because you haven't practiced this area of the law. So you might have no idea where to start, and I could tell you that really anyone can do it because I'm a perfect example. When I started, I had been a commercial litigator for a very short time and was a newspaper reporter all the rest of the time. So when I got my first case, I really had no idea what I was doing. And now I've taken affirmative cases from Gambia and Iraq and defensive from Eritrea, Somalia, and China. And then I did something a little different than an asylum case called cancellation of removal, and that was from Belarus. I found with my first case, it seemed a little hard only because it was a new thing. I also play jazz piano, and I found that learning piano was way more difficult than taking the first case. So it was really just the new thing that made it difficult. By my second case, I felt very comfortable. There is one part of this that's incredibly difficult, though, and you probably can guess what it is. It's the reality of the lives of the people you're working with, your clients, how difficult a time they had getting here, how difficult a time they had in their country. And so far, I've been lucky to win asylum. And each of my clients, once they're here and they have asylum and they can stay, it's just the beginning. They have to start working their way up, finding a job, getting their family over. So that is a hard part about it. When I first started doing asylum, I always thought I would love to get up here and say to everyone, okay, now I can tell you the things that Betsy and Jordan don't really tell you. But now that I'm here doing it, the truth is there really isn't anything they don't tell you. And if they don't tell you and you have a question, just ask. I feel that NERP, I couldn't do this without them because I don't have the background to do this kind of work. So I would be at a loss. Whenever something comes up where I have a question, I just email Jordan or Betsy or whoever, and within a day I get an answer. I sort of developed a format where I sort of ask the question and answer it the way I think is the right answer, just to sort of save them time going through. And they either say yes or no, and it just seems like a quick way to do it. But they've always been incredibly helpful, and I've never felt like I've been alone. I did have a problem that I was afraid was going to happen, and sure enough it did. I had an Iraqi client with a translator, because I don't speak any Iraqi or Arabic. I don't speak any Arabic or Farsi. But anyhow, so everything was working great because I had this translator. But what would happen if something happened to the translator? I didn't know anyone else who spoke Arabic to come on in and help, and there was no way I could communicate with my client. Well, this is exactly what happened. I didn't know what to do, so I emailed Jordan, and it's not NERF's responsibility to find the translators, it's the lawyer's responsibility. But even so, within about 2 or 3 hours, I had an email from a translator who was ready to help me. So they really do everything they can to help you, which is great. One thing that surprised me about taking these kind of cases is I wasn't really looking to expand a practice, but every single case I've taken, I've had referrals to other clients who've wanted me to work on their cases. So if you're interested in starting an immigration practice, I couldn't think of a better way to do it than to start with something like this. The materials that NERP gives you pretty much tells you everything you need to know. And I was a little skeptical because I'd only seen their materials, so who knows what else is out there. So I started looking on the internet to see what else I could find that would possibly be better, and there was nothing better. So you can look around, but really what they give you is the best that there is. And one day, I was stuck in Tacoma working on something, and I needed to print something out, so I went to NERP in Tacoma, never having set foot in the office, and I got there a little bit before lunch, and they were so happy to help me, and they also invited me to stay for lunch. And that sort of shows what they feel about the pro bono attorneys. They're glad to have you around and could not be more helpful. Before I went to the detention center that Betsy was talking about, I'd never been to a jail before, and it wasn't high on my list of things that I felt like I really wanted to do, but it was my only choice because my client was detained. He was from Somalia, so I went. And I'm not going to tell you whether or not I got lost the first time I got there, but if you ever get lost, call me and I can tell you how to get there. Practically speaking, from Seattle, it's incredibly easy because it's right off the freeway, and although I meet most of my clients in downtown Seattle when they're not detained, I find that time-wise, it really doesn't take any more time to get to the detention center. And, you know, I'm sure a few more minutes, but it's not a big time sink that I thought it might be. I think it's really great if you take your first case as a detained case because it allows you to see the environment where the clients live, get a feel for the immigration system that you might not if you weren't seeing them detained at the detention center. And I also felt it was really helpful because it's obviously a very controlled environment. Your client is always there and ready to see you whenever you need to go. Even if at the last minute your schedule changes, you can just get in the car and go and see your client. Also, you meet other lawyers who are doing similar work, and sometimes you have to wait a little while for your client to be ready for you to go in and see them. And that's a great time to meet other lawyers. They give you lots of tips. They let you know about the practice, what they're doing. So I found that part was invaluable too. So once you decide you're going to sign up, you take a case and you have the first meeting with your client. The thing that surprised me the most was that many times the client thinks that this is just administrative, that you're just going to be filling out some papers and then they'll get asylum. And when you tell them that that's not the case, it's always a shock to them. And often you're the first person they meet who tell them that, or it really sinks in. So that it's hard to deal with that, but they get used to it and then you go on. Usually I use my first meeting to assess the case and see what's going on with the client and get a sense of what the work is that will have to be done. And I try to explain to my client what all that is. I find that the first meetings are incredibly emotionally exhausting for the client because suddenly they're having to talk about things that they've kept to themselves for a long time. For example, if they've been tortured. And it's very hard for them to go into all those details with me, a stranger. So I try to take it really slow. And I don't expect to get a lot done at the first meeting other than they just get to know me and we sign retainer agreements and things like that. If things are going really well, we start to fill out the I-589 asylum application, which is an application that you submit as part of a full asylum application. Often at the master calendar hearing, you'll give the I-589 application, and then later on, when you have your individual hearing, that's when you submit all the extra work, or a little bit before it, but that's when you go into the case in more detail. The other day, I heard Jordan say that the most difficult, or the part that he spends the most time on in any case, is the declaration. And I was glad to hear him say that because I feel exactly the same way. The declaration is obviously the client's personal statement, and that's what you use to show what happened to the client, and you can explain why he was persecuted and for what reason he was persecuted and whether or not he fears future persecution based on what happened to him. The first thing I learned is when you talk to a client and you call it the declaration, they look at you and their eyes just glaze over because it sounds so legalistic to them. So I learned to call it the personal statement, and then they know exactly what I'm talking about. I asked them to do a draft of their lives, thinking that if I get their entire biography in a very detailed way, we can begin to tease out what's important and what isn't. And to me, this doesn't seem that hard. Just tell me everything, and don't be afraid to include more than you need to know. But it turns out it's hard for people to do this. They either selectively leave out important things, or they don't go into nearly the detail that I'd like them to. So I've sort of developed a system of asking 8 or 10 questions that I want to be answered, and that kind of helps them get through it. What's most interesting to me, though, is without meaning this to happen, the clients are often not their own best friend. It happens, I would say, in almost every case I've had. For example, I had a client from Somalia who we were trying to show that he was being persecuted because of his membership in a clan. And in that case, it's very important, the way the law is, not to show, it's important to show that it wasn't just general strife, but that the person was persecuted because of the clan he was a member of. My client was persecuted when he was 8. A neighboring clan came and upset his household, attacked him, attacked his family, and then went on. And when my client came to this country, he was in his late 20s, I think. And the problem is he was convinced that he was persecuted for no other reason than he happened to be in Somalia in the wrong place in the wrong time. It had absolutely nothing to do with his clan membership. And it was so crucial to his case that it did have to do with his clan membership that I really tried to make sure that he was correct or not, because it would be really helpful if he was wrong. So I asked other relatives of his who were there at the same time, And they assured me, oh no, it was because of the Klan membership. It absolutely was. Our Klan lived in this separate area. There was no one from other clans. The people who persecuted us would have left us alone, but for the fact we were from this Klan. So it was good to talk to other people and then explain to my client why it was a little different from what he thought as an 8-year-old, and that was really helpful. And another thing that's been interesting to me is political opinion cases. Clients who feel that they were persecuted because of their political opinion. Well, obviously, the first thing I want to ask them is, so what is your political opinion and how did you show it? And the 2 or 3 cases that I've had like that, each person who comes here, they really backpedal on their public opinion, or their negative public opinion of the government. And I think it's because they're afraid that if they come here being against their government, we aren't going to like them because we're going to be concerned that they're against our government. When I talk to them, they kind of say yes once we get through it. So it's another case where I had to ask lots of their friends, what were they like in their country? Did they ever say anything bad about the government? And then to kind of tease that out a little bit. And just recently, another thing, I'm working with a client who is claiming persecution because he was persecuted because of his religious practice in China. And he's very good at talking about his religion. The problem is the translator who translates from Chinese to English, and the translator doesn't know anything about Christianity. So it kept seeming to me like my client didn't know anything about Christianity because the translator kept giving very vague pieces of information about Bible stories, for example. And then all of a sudden, in the middle of my client's Chinese speaking, I heard Egypt, and I heard Esau. And then when the translator translated, he didn't say those words. So all of a sudden, I realized what was going on, and I assured my translator that it would be okay just to translate it how he could, and I would get the details. So that could have been a case where, had I not thought about that, it would have seemed like my client didn't know much at all about Christianity, when in fact it was the translator. The next issue that to me is really important is credibility. Often these people leave their countries, and it's very hard to prove the persecution that they're claiming, which would be their reason for obtaining asylum here. And so I found that often all that you need to do, or try to do, is prove any part of their case. Anything that you can show that's true, just to show they are who they say they are. That lends a lot of credibility. And I also find if you can get as many Americans who aren't at all interested in this client, who are professionals in other fields, who can say, yeah, I believe this guy, that really helps. Even if in the end, no one can prove what actually happened when we're claiming the persecution, and it just goes up to whatever the client says it is. It's much easier to believe him. For example, I had an Eritrean who had a master's degree in soil sciences. Who knows if he really did? He brought his diploma. I don't know if that diploma was real. So I figured, how can I prove his credibility? And I thought, maybe there's someone at the UW who teaches soil sciences, and sure enough, there was. And I arranged for my client to meet with him, and the professor tested him on his soil abilities. And so then he could have a declaration saying, yes, this guy was a soil scientist. So then I could show for sure he was who he says he was, and I think it made the rest of his case more believable. I had a Somali who came with no identity documents because there weren't any to be had in Somalia. But when he was in Kenya, he was a waiter at a hotel, and the owner of the hotel Federal Expressed me his waiter ID card. And although that wasn't much, it was something, and it corroborated his story. I also tend to get medical and psychological evaluations whenever I can, if it's at all necessary, because it's just 2 more people who will say, yes, I believe this man. And then I go to local community leaders or experts. This surprises me a lot. As the attorney representing the client, we're allowed to introduce expert testimony. So in other words, the declaration that the client writes, I can give that to an expert to read and say, yes, I believe this is true for the following reasons. And because of what I knew in the country at that time, this makes lots of sense. That's so incredibly helpful. But what surprises me is the government never introduces experts, at least in the cases that I've had. So if I introduce, say, 2 experts, that's 2 more than they have. And I just feel like that really stacks the deck in my client's favor. And then the only thing that I really have to worry about is that my client will testify consistently to his story. So in the end, if your client testifies consistently to the story, and then you have everybody else saying, yeah, we believe it, I just feel like a judge will sleep really well at night granting asylum, having all those people believing my client. One thing that was scary to me before I did this was the hearing. I'd never appeared in court, and I just thought that was something I didn't really ever need to do. But I had the client, and he was going to court, so there I was. I saw one before I did it, and that made it incredibly helpful just to kind of know what I was getting into. But in the end, it's by far the easiest part of the whole thing for me, because you've already proved your whole case. You've submitted your brief 10 to 15 days before the hearing. You know the case backwards and forwards. You ask your questions. I find that the government cross-examination isn't difficult. Sometimes it seems a little vicious to me, but it's because they're grasping at straws, and that could just be my experience so far. But the hearing is the fun part. Now I'm wondering if anyone has any questions.
We do have one question that came through. What types of cases would NERP consider being of the most need at the detention center?
So the question that came through was, what kind of cases does NERP consider to be of the most need at the detention center? So luckily, Betsy just did a presentation on asylum cases, because those typically are the ones that are the most need. Reason being that asylum cases, as Betsy kind of showed, have so many components to it. The declaration, the law is usually kind of complicated, and so a pro se person really has no hope of doing any of that on their own very well. And the judges have also told us that if there's one type of case they want to see in court with an attorney, that asylum cases are it.
I would just add that for asylum seekers also, oftentimes they're going to be people who are just coming to the country and may not know anyone here, most likely have 0 money or very little money to track down documentation that might help them with their case. So, because of those reasons also, in addition to what Betsy said, asylum, anyone who's interested in working on an asylum case, that'd be greatly appreciated. We don't have a lot of time to answer any additional questions, but I had just a couple frequently asked questions that hopefully will answer questions that might exist out there. The first is, do I need malpractice insurance? This is the question that comes up a lot with pro bono attorneys, and the answer is no, you do not need malpractice insurance to take one of our pro bono cases. When you take a case through the Northwest Immigrant Rights Project on a pro bono basis, you are covered by our malpractice insurance. And a lot of our pro bono attorneys are like Betsy. Other of our attorneys are fresh out of law school. They do not have malpractice insurance. They don't have any office. They have no prior experience. So, having access to the malpractice insurance is helpful for those individuals. How many hours should I expect to spend on one of these cases? That can vary quite a bit. I usually tell pro bono attorneys to expect to spend anywhere from 50 to 75 actual work hours on a case. That will usually be spread out over several, if not many, months. So the commitment, as long as you're decent at allocating your time, will not be all that intensive. Obviously, the time commitment can vary a lot on a case-by-case basis. Certain of our clients are very skilled at discussing their story. Certain of our clients have already done country condition research for you. And those clients are probably gonna be easier and faster to work with. Other of our clients, maybe severely traumatized and have a very difficult time talking about what happened to them, or, there may be cultural or language issues that cause it to be a little bit delayed. But I think if you anticipate spending, 50 to 75 hours, that's probably a realistic expectation. And when attorneys finish up a case, they usually report back to me, and that's generally the range of hours that people spend. Do I have to appear in court? That was kind of answered already, but the answer is no. If you would prefer not to appear in court, we do have options for cases that are called affirmative applications, which was briefly mentioned by Betsy, but those are applications for some sort of immigration benefit, like asylum or a family-based immigrant visa petition that someone is filing without the government trying to deport them. Those cases are filed directly with the Department of Homeland Security, and depending on the type of case, may or may not involve an interview. So if you're an attorney out there who does not want to appear in court, we can find a case for you. How many months do these cases usually last? Again, that's going to depend a lot on what type of case you're working on. In the detained context, I think you can probably see a case from beginning to end in 6 months, 6 to 8 months. In a non-detained setting, it's going to be longer. We can, if you want to take a case, we can discuss what the likely timeline would be for that particular case. Who's responsible for fees related to the case? The clients understand that the pro bono attorney is offering free legal services, and that is it. The attorney is not agreeing to pay filing fees. They're not agreeing to help them with their landlord-tenant disputes. They're agreeing to help them with their immigration case. The reality is, however, that the vast majority of our cases either do not have a filing fee, or if they do have a filing fee, it is waivable. And because we only help people who cannot afford to hire private attorneys, most of our clients will qualify for fee waivers. What if I cannot continue representing my client? This is a very important one. When we refer a case to a pro bono attorney, we very much see it as your case. We see our role as support to you to ensure that you can see your case through. We expect the attorney to see the case through to the end, and to really think through the decision to take the case at all very carefully at the outset, before committing. And I would just assure anyone out there that we would much rather you not take a case at all than to take a case and then decide that you're moving to France in 3 months, and have to give the case back. We do not have the capacity to reabsorb cases once they've been referred out. And, quite frankly, if the case is before the court, we don't even really have the authority to relieve you of your commitment to your client. What if I do not have an office of my own? Our Seattle office has, I think, 4 or 5 conference rooms that you can use. You would just need to let me know when you want to use them, and they're almost always available. They have computers and phones in them, and they're comfortable. If you're working on a detained case, you would be meeting with your client at the detention center, so that wouldn't be an issue. Other people I know have reserved conference rooms at libraries. I know the local law schools also have conference rooms that you may be able to reserve. And a lot of attorneys out there may have their own office if they work in a firm, and you're more than welcome to meet with your client there. How do I get started? This is the most important piece. If you are at all interested in taking a pro bono case, just call or email me. I am more than happy to sit down with you for 45 minutes, an hour, to go into much more detail about what is involved, what the commitment looks like, what your day-to-day work looks like on a case, and help you figure out, first of all, whether you do want to take a case, and if you do want to take a case, what type of case best suits your interests and So please just contact me. My contact information is on the slide, and thank you for attending this webcast.
I believe that concludes this presentation. Thanks, Jordan, Betsy, and Betsy. You do very interesting work, and I think we can all be proud to contact you and do some work with you. I mean, sincerely, that's very interesting stuff.
Are we off the air?
You are